I think that there is a logical flaw in this argument. It's not a racist flaw. There are other racist problems in the opinion. Plessy v. Ferguson, which is an 1895 U.S. Supreme Court case, is undoubtedly one of the most infamous court cases in U.S. history, the other major contender being Dred Scott. Let's start by just going through the background information and context. In 1890, this is after the Civil War, decades after the Civil War, the state of Louisiana passed something called the Separate Cars Act. And what this law said was that in the state of Louisiana, there had to be separate cars for the white and black races. Or if there didn't have to be separate cars, then a single car had to be divided in some significant sense. There had to be a divider put in the car. Okay, so this is a Louisiana law. And this case is going to be the case where the constitutionality of that law is challenged, and the U.S. Supreme Court is going to decide, no, that's okay, that this law requiring segregation on railroads is constitutional. It's compatible with, in particular, the 14th Amendment. Now, here's the thing. You may know that the U.S. Supreme Court has the authority to decide whether laws, state laws or federal laws, are constitutional. It's called judicial review. And the Supreme Court gave itself this authority in another very, very famous, very, very fascinating case that we're going to actually talk about later in this course. But the Supreme Court can't just pick any law that it wants and decide whether that law is constitutional or not. What has to happen is that the right case has to work its way up through the courts so that the issue is presented to the Supreme Court, and only then can the Supreme Court issue a ruling or issue a judgment as to the constitutionality of that law or statute or whatever. And so what often happens, and that's what happened in this case, is that there's a setup. That is, there was this guy, Homer Plessy. Homer Plessy was persuaded by a group of legal activists to sit in the white car and then be arrested. Homer Plessy was 1/8 black and 7/8 white, so he had very fair skin. And the idea was he was going to be arrested, and then this case was going to be appealed and appealed all the way up to the Supreme Court, and then these activists in Louisiana in the 1890s hoped that the Supreme Court would strike down the Separate Cars Act as unconstitutional. Now, there's a problem with this. I mean, one problem that you might run into if you're trying to orchestrate this kind of thing is that you could arrest Homer Plessy for a whole bunch of stuff. You know how this works. This is how it works with cops. They arrest you for something. They find something like loitering, right? And that's what you're arrested for. And so the worry was that Plessy would sit in the whites-only car, and then he'd be arrested for something like loitering, and then they can't fight that and appeal that loitering is unconstitutional all the way up to the Supreme Court. That wouldn't get at the problem with the Separate Cars Act, right? So what they did was they hired a private detective. And this private detective at the time was a person who had the authority to arrest people and book them into jail or whatever. And this guy could specify what he was arresting Plessy for. So this group of activists, they hired the detective who would do the arresting also. So Plessy and the person that arrested Plessy for sitting in the white car, they were all in on it together. And in fact, the railway company was warned about this in advance. The railway company knew what was going to happen, and the railway company, they weren't, I don't know if they were particularly anti-segregation, but segregation was bad for their profits because it often meant that they had to run additional railway cars, so that it cost them money. That's the situation, that's the setup. And then what we read for today was the opinion by Justice Brown. It's an opinion rejecting a petition for a writ of prohibition. That's what Plessy's lawyers wanted. And Brown says, no, you don't get the writ of prohibition. A writ of prohibition is an order that a higher court issues to a lower court, telling that lower court to stop prohibiting them, telling them to stop enforcing some law. In this case, it would be on the grounds that that law is unconstitutional, on the grounds that this law, the Louisiana Separate Cars Act, violates the 14th Amendment. There's also some discussion of the 13th Amendment. We'll get to that. So Ferguson, who's Ferguson? Ferguson is the name of another judge, a judge that ruled that, that Plessy needs to be punished for violating this law. When the case worked its way up to the Supreme Court, it was no longer Plessy v. whatever it was, the state of Louisiana or something like that. Now it's Plessy v. Ferguson. That is, the question is whether the Supreme Court should issue this order to this judge, saying, don't enforce this law. And indeed, it would apply to all judges. Don't enforce any laws like this because those laws are unconstitutional. So the challenge that comes from the plaintiffs are the ones in a civil case like this, the ones who are suing, that's Plessy and Plessy's lawyers, right, who are saying that this law should be deemed unconstitutional. The plaintiffs are claiming that this Louisiana law requiring separate railway cars violates both the 13th and the 14th Amendments. Okay, so what are these amendments? Well, the 13th Amendment outlaws slavery. And the 14th Amendment includes a whole bunch of stuff, but one thing it includes is the idea that every citizen is owed equal protection under the law. That is, every citizen has a certain set of rights, and the state, the legal system, must protect those rights for everyone equally, provide equally vigorous protection of those rights. So what we read for today was the majority opinion written by Justice Brown of the U.S. Supreme Court in 1895 or thereabouts. And it was a 7-1 decision. There was only one justice who didn't agree that this law doesn't conflict with the Constitution. It's not unconstitutional. So the court upheld the Separate Cars Act and very famously, infamously, ruled that laws like this, laws requiring segregation, don't violate, well, the 13th, certainly not the 13th, but they also don't violate the 14th Amendment so long as the facilities, the segregated facilities, are, you may have heard this phrase, separate but equal. So that infamous phrase comes from this court case. In the opinion that you read, the first thing that's noted is that rather obviously, a law requiring separate railway cars does not violate the 13th Amendment. Like, there's no conflict between outlawing slavery and requiring segregation. So Brown points this out, and Brown even says at the very end of the section about the 13th Amendment, and plus the plaintiff, that is, plus Plessy and Plessy's lawyers, they're not really serious about the claim that the 13th Amendment is violated by this law. And Brown is basically right about that. The real action is at the 14th Amendment. Here's the question. Does segregation of railway cars, or really of anything, any facilities, does that kind of segregation involve the state treating people unequally because of their race? And Brown notes, and it's very important for Brown, that the 14th Amendment doesn't require that the races be given equal status in society. It just requires that they be given equal status by the law or by the state, right? It could be the case, so claims Brown, that one race is treated equally to another by the law, but then when people go about their private lives, that race is treated horribly. And as far as Brown is concerned, well, that distinction is possible, and also that kind of that kind of difference is entirely compatible with the 14th Amendment, according to Brown. So if this argument is going to work, then Brown needs to establish the following claim. The state requiring segregation, the mere separating of the races, Brown needs to establish, does not in itself involve the state treating one race as inferior than the other, or treating the races unequally. That's the claim that Brown needs to establish. And in the opinion that we read for today, there's one paragraph where the actual argument for that claim happens. And so what I want to do is I want us to just spend our time understanding what that argument is and if there are any problems with it. Here's the argument. It happens in 4 sentences. Okay, those are the 4 sentences. This, it seems to me, is where the argument happens. I think that there is a logical flaw in this argument. It's not a racist flaw. There are other racist problems in the opinion. In this argument, as Brown presents it, it seems to me that there's a logical flaw. So what we're going to do is first we're just going to read through this passage. Then I'm going to have to explain a little bit of logic, a little background logic, so that we can understand what the structure of this argument is. Then we're going to pull the argument out of here and analyze it and see what the problem is. So first, let's just read the passage. Don't worry if after reading this passage you're a little confused and it's not 100% clear what's going on. The point, of course, is that in the end, Brown is arguing for the claim that the Separate Cars Act, that segregated railway cars, does not thereby treat the races unequally. It does not involve the state treating the races unequally. We consider the underlying fallacy of the plaintiff's argument. The plaintiff is Plessy and Plessy's lawyers. We consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the 2 races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that constriction upon it. The argument necessarily assumes that if, as has been more than once the case, and is not unlikely to be so again, the colored race should become the dominant power in the state legislature, and should enact a law in precisely similar terms, it would thereby relegate the white race to an inferior position. We imagine that the white race, at least, would not acquiesce in this assumption. Okay, so there's some kind of argument going on here. It somehow involves a switching of the positions in society. There's a reference to, I think, that Brown is making a reference to the early Reconstruction after the Civil War, when in some ways newly freed slaves were in politically dominant positions. What Brown is imagining or sort of recalling is a case where blacks are in charge, they're dominant, and they make a law requiring whites and blacks to be segregated. The argument somehow involves that kind of reversed scenario. But if we're going to understand what the argument is, we need to understand one form of a logical argument, and that form is called modus tollens. Modus tollens is a Latin phrase for a pattern of thinking, and the pattern looks like this. Premise 1, step 1 of the argument. If OJ is the murderer, then the gloves fit OJ's hands. Okay, so these are the murder gloves. These are the gloves that the murderer obviously wore, and they have the blood on them and all that, right? And so if OJ is the murderer, then these gloves should fit his hands. That's the first claim. By the way, so the gloves, you maybe know, they didn't fit his hands. He tried them on famously in court, and the prosecution didn't require him to try them on in advance, not in front of the cameras and not in front of the jury. And when he tried to try them on, they didn't fit. That it is thought by some turned out to be a result of the fact that they were stored in certain temperatures, right? They were locked up in an evidence bag, and it got colder and hot and cold and hot in their leather gloves, and they shrunk. So this premise, by the way, might not be true. It might be false that if OJ is the murderer, then the gloves fit OJ's hands because, well, the gloves have shrunk. So it's no guarantee that if they don't fit his hands that he's not the murderer. Anyway, so this might be false, but let's just assume it's true for the moment or for the sake of discussing this argument. So if he's the murderer, then the gloves fit him. Step 2, premise 2, the gloves don't fit his hands. So therefore, OJ is not the murderer. This was part of the argument that was offered by OJ's defense team. This pattern of thinking is called Modus Tollens, and in abstract, it looks like this. This is the schematized or schematic way of writing this type of argument. If you've taken an Introduction to Formal Logic course, then you're very familiar with this. You've heard of Modus Tollens before. You understand this way of writing. But if not, don't worry. You should just notice that these claims fit this form, right? So if something, then something else. If P and Q are just variables that stand in for sentences or claims, right? P is OJ is the murderer. That's P. If one thing, then some other thing. Then Q, the gloves fit OJ's hands. But not Q. That is, it's not the case that the gloves fit his hands. That's premise 2, not Q, right? If that's the case, then not P. Then OJ is not the murderer. OJ is not the murderer. That's Modus Tollens. Modus Tollens is good. There's nothing wrong with Modus Tollens. It's so good that it's got a Latin name. That's how long ago people realized that this is a legit form of reasoning, a legit pattern of thought. This argument, it seems to me, is fundamentally a Modus Tollens argument. Here's what this argument looks like when you translate it into this, 1, 2, 3, premise, conclusion form. I should say a few things. First of all, this is my reconstruction of the argument. The whole thing that I'm telling you right now, by the way, with Modus Tollens and there's going to be a problem with this argument, this is all me. I'm making this up, or I'm making all of these claims. I suspect that others have realized this before because I suspect that there are lots of other people who have taken Introduction to Logic and then have read this court case. So I don't think that I'm the first person to realize this, but all of this reconstruction is from me. I'm making this up on my own, and I'm making the claim that there's a particular fallacy involved in this argument, a particular mistake. This is something that occurred to me when I read it, although I'm not the only one that this occurred to, I assume. When reconstructing the argument here, I have to mangle this a little bit. Just a little to make it fit into some logically valid form. This, I think, definitely is the best argument that you can pull out of this. So let's go over the argument. Let's understand what the argument is. Then we'll go back into the text. We'll see that the argument is in the text. And then we'll see what the problem with the argument is. Premise 1. If segregation did entail inferiority, then when blacks impose segregation, that is, in the case where the blacks control the state legislature and they're the ones that decide to pass some segregationist laws, then in that case, the white race would be inferior. Okay, that's premise 1, that if segregation labeled a group with the badge of inferiority, right, then it would label that group with that badge even in the case where the roles were switched. That's premise 1. Premise 2 is that, but when blacks impose segregation, the white race is not inferior. That is, when the roles are switched, the white race doesn't become inferior. And the conclusion is, therefore, segregation does not entail inferiority. And therefore, segregation and the Separate Cars Act in Louisiana or whatever, so Brown is claiming, does not violate the 14th Amendment. It does not undermine equal protection for all citizens. That's the argument. You can see that this is a form of modus tollens. If P, here's P, right, then Q. But not Q, there's not Q, so therefore not P. This is modus tollens. It looks on the surface like this is a valid argument. That is, the structure of the argument leads to a true conclusion if the premises are true. Now, the fact that this argument looks like it fits into modus tollens, by the way, it's going to turn out that it doesn't fit into modus tollens, but the fact that it looks like it fits into modus tollens, well, even if it does fit into modus tollens, that still doesn't mean it's a sound argument. That still doesn't mean it's a good argument, because it might turn out, of course, that one of the premises is false, in which case the conclusion isn't guaranteed to be true. So it could still be a bad argument even if it did fit into modus tollens. But it's definitely a bad argument because I'm going to claim it doesn't even really fit into modus tollens. We're going to see what the problem is. But before we see the problem, let's go back to the text and just convince ourselves that this is the argument that's being made. All right, let's start with the first sentence. We consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. That's the conclusion. I mean, written arguments often start with the conclusion. That is, Brown is saying it's not the case that segregation, right, means that blacks are inferior. It's not the case that segregation means that blacks are inferior. This is the conclusion we get it in the first sentence. Then he says, if this be so, that is, if what be so? If the colored race is inferior or labeled as inferior, if this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that constriction upon it. This sentence actually doesn't fit into the argument. You don't need this sentence. This is sort of a throwaway insult or something like that. It's just the claim that, look, if the colored race appears to be inferior, it's not because of anything in the act. It's because of something that is done by the colored race. That's what that sentence means. That sentence is not needed for the argument. That's just sort of an extra thing he added. Okay, so then Brown says, the argument necessarily assumes that if, as has been more than once the case, I think he's thinking of Reconstruction right after the Civil War, as has been more than once the case, and is not unlikely to be so again, that is, and it will probably happen again, the colored race should become the dominant power in the state legislature and should enact a law in precisely similar terms. It would thereby relegate the white race to an inferior position. This is premise one. If segregation did entail inferiority, then in the case when blacks were in charge and imposing segregation, then the white race would be inferior. And then he says, we imagine that the white race, at least, would not acquiesce in this assumption. This is sort of a very softy way of saying premise two. But in that circumstance, when blacks would be the ones passing a segregationist law, the white race would not be inferior. Okay, this, I claim, is the argument. What's wrong with this argument? Well, in order to understand that, we need to understand one other term, and that term is equivocation. Equivocation is a philosopher's term for a kind of argumentative fallacy. It's when you have a term or a word, right, like the word bank, that has two different meanings, or can be understood in two different ways. It's ambiguous. So the word bank in English can either refer to the side of a river, the bank of a river, or a financial institution, a bank. So equivocation is when you use the word bank over the course of an argument in both ways, slipping secretly between those two meanings in such a way that the argument works if the word had meant the same thing all along, but it really didn't mean the same thing all along. And so the argument seems like it's a valid argument when it's really not. Right? So for example, let's say I make the following argument. I say, a bank is a good place to keep your money. And then I say, the north side of the river is a bank. Therefore, the north side of the river is a good place to keep your money. Is that a good argument? No, because the first step in the argument, a bank is a good place to keep your money, is only remotely plausible if the word bank means a financial institution, with like a vault or whatever, and they take people's money and pay them back interest, and then they loan money and those people give them interest, that whole thing. It's only plausible that a bank is a good place to keep your money if we're talking about a financial institution, not the side of a river. But then the second step in the argument, the second premise, which was the north side of the river is a bank, well, that's only plausible if bank means the side of a river, whereas the north side of the river is not a financial institution, right? So that premise is totally implausible if bank means the same thing that it meant in the first premise or the first step of the argument. And so the conclusion just doesn't follow. That's equivocation. That's what's going on here. I want to pause. See if you can figure it out yourself. What word or phrase is being equivocated on? What word or phrase is being used to mean two different things in this argument, making the argument seem better than it really is? All right, I'll tell you. I think it's inferior. I think Brown, in this passage, is operating with two different notions of inferiority, and he's sliding between them. And it's only by sliding between them that the argument looks like a decent or a half-decent argument. The difference is this. There's a difference between labeling some group inferior, being labeled inferior, being called inferior, and actually being inferior. That's the difference. I think that in one of the premises of the argument, Brown has to use one of these to make that premise plausible. But in the next premise of the argument, he has to use the other one to make that premise plausible. So actually, he's switching between two different meanings of the word inferior. And by doing so, this argument counts as equivocation. It's not a valid argument. Here, let's go through. If segregation did entail inferiority, then when blacks impose segregation, the white race would be inferior. There, he means labeled as inferior, or called inferior, or said to be inferior, not actually inferior. Here and here, right? The question is whether segregation treats one group as inferior, labels them as inferior, right? Stamps them with a badge of inferiority. To stamp something with a badge is to call it a certain way. It doesn't make it that way. Stamps can be inaccurate. Badges can be inaccurate. So the question here, right, this is only a relevant, plausible premise, right, if we understand inferior to mean labeled as inferior. If segregation stamped a group, called a group, treated a group as inferior, then when blacks impose segregation, the white race would be stamped as inferior. That is, well, the only plausible reading of this sentence, or remotely plausible reading. Well, yes, if segregation did label one group as inferior, then if the roles were switched enough of the way, that is, blacks were really and truly in the dominant position in all the ways that they would need to be dominant, right? And whites were really in the subordinate position in all the ways that they would need to be subordinate, well then, imposing that segregation maybe would label the white race as inferior. So this is only going to be plausible, at least it's only going to be plausible to Brown, if inferior means labeled as inferior. But then premise two, but in that circumstance where the blacks are the ones in the dominant position and they're the ones imposing segregation, but when blacks impose segregation, the white race is not inferior. This is only plausible if inferior means actually inferior. That is, Brown is saying, but the white race wouldn't actually be inferior, right? If you really and truly switch the roles, maybe the white race in that circumstance would be labeled as inferior. This premise is only plausible if Brown is denying that the white race would actually be inferior. So we've switched from this to this, and these are just two totally different things. And so this conclusion simply doesn't follow. this is not really an instance of modus tollens, which is a good form of argument. It's an example of equivocation.